Hello, my name is Ruben Reyes. I'm an Area Assistant Vice President and Compliance Counsel for Arthur J. Gallagher & Company, a global risk and benefit consulting firm. I'm also currently the chair for the State Bar Committee on Group Insurance Programs. Today, I'm going to talk for a few moments on healthcare reform, in particular, healthcare reform updates for 2015. Since its passage in early 2010, the Patient Protection and Affordable Care Act has gone through significant developments over the last 5 years. In fact, as of the end of 2014, there have been close to 13 million words of regulation and guidance that have been released since its passage date in March of 2010. All of these changes have relayed significant developments, not only on individuals, but on insurers and employers of all sizes. So what has changed over the last 5 years? We have seen significant developments on the market reform side. Several benefit changes such as the elimination of pre-existing conditions, no-cost preventative care, and no-cost essential health benefit limitations as well. These have been warmly received by the public, but there have been several developments on both individuals and employers alike. On the individual side, we've seen the new mandate applied to all American citizens that they obtain minimum essential coverage or they could be charged a penalty on their tax returns. On the employer side, we've seen a mandate that went into effect in 2015 that required applicable large employers ranging in size from 50 full-time and full-time equivalent employees to provide minimum essential coverage that also provides minimum value and is affordable to the employee or risk facing a penalty. As you can assume, healthcare reform has also raised several legal challenges. The most recent is the King V Burwell case, which asked the question of whether or not the federal government had the ability to issue premium tax subsidies in the marketplace that were developed by the federal government. This is a difference in the legislation of how it was written, that marketplaces must be established by the state. Unfortunately, since its passage, only 16 states at the time of the King v. Burwell case had actually implemented a state-run exchange program. That meant 34 states had marketplaces that were facilitated by the federal government. So the plaintiffs argued in that case that the federal government did not have the right to issue premium tax subsidies to members that enrolled through a federal facilitated marketplace. This is because the language of the bill actually required that the marketplace be established by the state. The King v. Burwell case was heard in March of 2015, and a decision was rendered by the U.S. Supreme Court in June of 2015. In a 6-3 ruling, with the majority written by Chief Justice John Roberts, the Supreme Court ruled that the federal government and the IRS did have the right to clear up ambiguous language in the Patient Protection Affordable Care Act in regards to whether or not the federal government could issue premium tax assistance to individuals that received coverage in a federally facilitated marketplace. This obviously had a huge impact on several individuals who were currently receiving premium tax assistance through the federal marketplace. What this meant was that they can continue to receive those premium subsidies to help offset the cost of their health care coverage through the marketplace. What it also meant was that employers, under the employer mandate, could continue to be subject to the employer mandate penalties if they did not offer affordable coverage to their employees and one of their employees went on a federal marketplace exchange and received a premium tax assistance. So employers had to continue to move on with the development of the employer mandate and to abide by the rules that had been established therein. This was a significant development for healthcare reform, as if the court would have ruled in favor of the plaintiffs, it would have essentially dismantled the program that was offered under healthcare reform. You would have had 34 states and members in those 34 states that would have no longer been eligible for premium assistance. And employers in those states would have not been penalized if they had not offered coverage for their employees. So as you can see, the decision had a huge impact on the future of healthcare reform. So where does that leave us today, moving forward in 2015 and beyond? Well, employers and individuals are continuously obligated to maintain their coverage that is both minimum essential and provides minimum value and is affordable. So we have seen that the IRS, in relation to this development, has developed new reporting requirements for employers. This is a significant reporting obligation on employers moving forward, and it's based on the 2015 calendar year. Employers will now have to submit to the IRS two new forms under Section 6055 and Section 6056. Section 6055 covers minimum essential covered employees, and employers will have to report to the IRS all individuals who are currently covered under their plan. This helps the IRS determine, for purposes of the individual mandate, who is complying with the regulation and therefore not subject to a penalty. The second piece, under Section 6056, requires applicable large employers to report whether or not they are making an offer of coverage to employees, full-time employees and their dependents, and whether the coverage is minimum value and also affordable. This piece of the reporting allows the IRS to determine which employers are complying with the employer mandate and whether or not they should be assessed a penalty. These two new reporting requirements will be submitted to the IRS at the beginning of 2016. Employers will have to file these forms to the IRS and also issue a statement to each employee covered by the plan, or they could be subject to a penalty, $250 per return, up to a maximum of $3 million for the year. This signifies a significant reporting requirement under healthcare reform and is probably one of the most administrative burden requirements that employers will face. In addition to new reporting requirements, employers will have to take a look at their programs moving forward as they try to determine whether or not the cost of their coverage, the value, exceeds certain limits. This is due to a tax referred to as the Cadillac Tax, which places a 40% excise tax on benefit programs that are deemed too rich or exceed a certain value of benchmark benefit levels. This is an election year, and so we are starting to see several politicians talk about this Cadillac tax as it is due to take effect in 2018. We know that these developments will create additional challenges for employers and for individuals for years to come. And so with healthcare reform and these updates, we hope to provide additional information that will ensure that individuals have the information available to help them make their best decisions when looking for healthcare coverage for themselves and their families, as well as assisting employers with their reporting obligation and coverage requirements so that they can ensure that they are meeting the employer mandate obligations under healthcare reform. I hope to provide these new developments and updates to healthcare reform to assist employers and individuals with this task. Thank you.